Hello viewers, how are you all today? I am Dr. Ankit Shrivastava, Assistant Professor of Law at Rajiv Gandhi National University of Law, Patiala. I hope you are ready for another interesting session on the subject of Economics and Law Part 1. Today, we will be discussing a very important as well as interesting topic regarding market forms and the law in action. So let's begin. But first, let's discuss that what is market all about? What is market? The modern economy depends heavily on the market. Without a market, producers and consumers' action seldom makes sense. Most people understand the market as a location where products are bought and sold. In economics, however, the term market does not refer to a physical place. Instead, it serves as a channel for connecting consumers and sellers so that they can exchange goods at prices that are mutually agreeable. The main features of a market include, first one, buyers and sellers. In order for a market to exist, buyers and sellers must interact. A transaction doesn't happen unless the buyer and vendor get in contact. The second is area. It is easy to locate a market closer to a populated area. In the modern world, the market is not limited to one location. The online market is rapidly expanding and is not regionally restricted in the current era of the internet. A buyer can place an online order for a good from anywhere. Thus, the current market is both virtual as well as physical. The third is commodity. A good or service must be the subject of the buyer-seller transaction. Thus, a commodity becomes a necessary component of a market. Fourth is different forms of competition. The type of market is determined by the level of rivalry between the sellers and the commodities, which is based on the quantity of sellers in the market as well as the relationship between the items and services offered by various vendors. The fifth point is money transaction. In the modern world, money serves as the medium of exchange. In the market, buyers purchase goods and services from sellers by giving them money. Therefore, the market and money are an integral part of the market. Now, let's talk about the basis of different market forms. Various market forms may arise based on specific distinguishing features. Some of these distinguishing features include, number one, number of firms. So, the number of companies in a market reflects how much power a company has over the pricing of a good. A single company, for instance, can only supply a tiny portion of the market supply and as a result cannot significantly affect the market supply, by extension the price, if there are several enterprises in competition with one another. Analogously, in a single firm market, it assumes the exclusive role of determining the market supply, hence exerting significant influence over the price. The second point is ease of entry and exit of the firms from the market. In the long run, prices will remain constant and profits will be typical if businesses may readily enter a given market or exit it with little loss. Prohibiting new firms from entering the market gives established firms more control over their operations and the potential to make more money due to reduced rivalry. The third point is degree of product differentiation. It simply refers to how distinctive a given company's product is. The more distinctiveness, that is, or a higher degree of product differentiation a company can claim, the more discretion it has over how much to charge. When the products that several businesses supply are identical, the individual businesses are no longer in charge of setting the price of the market. Now, the four major types of market forms we'll be discussing next. An economy can be defined by a wide variety of market arrangements. There are four fundamental categories that classify market systems: perfect competition, monopolistic competition, oligopoly, and monopoly. They all have unique traits and presumptions that influence how businesses make decisions and how much money can they make. It is crucial to remember that not every one of these market structures is a genuine thing. Some are merely ideas. However, there are extremely significant since they can highlight key facets of the decision-making processes of rival companies. They will therefore assist you in comprehending the fundamentals of economics. So let's discuss the first form, that is perfect competitive market or perfect competition. Now, perfect competition is a market system in which a large number of small businesses compete with one another. In case a single corporation has no discernible market strength. Since no firm has the ability to influence market pricing, the industry as a whole produces the amount of output that is socially desirable. The idea of perfect competition builds on a number of assumptions. The first one is all firms maximize profits. Second, there is free entry and exit to the market. Third, all firms sell completely identical goods, that is homogeneous goods. And fourth is that there are no consumer preferences. Now, by looking at those assumptions, it becomes quite obvious that we will hardly ever find perfect competition in reality. Since it is the only market structure that has the potential to produce production at a level that is socially desirable, this is a crucial component. The stock market is arguably the best real-world example of a market with nearly perfect competition. The second form of market is monopolistic market or monopolistic competition. A market structure where a large number of small enterprises are in direct competition with one another is known as monopolistic competition. In contrast to ideal competition, that is the perfect competition, the companies involved in monopolistic competition provide similar but somewhat different items. They can raise prices within a set range because of their degree of market power as a result. Monopolistic competition builds on the following assumptions. First, that all firms maximize profits. Second, there is free entry and exit to the market. Third, firms sell differentiated products. And fourth, consumers may prefer one product over the other. Now, those assumptions are a bit closer to reality than the ones we looked at in the perfect competition. However, because the companies have more power and can somewhat influence market pricing, this market system will no longer produce a level of output that is socially desirable. Now, the third form of market is oligopoly market. An oligopoly is a market structure in which a small number of suppliers hold a dominant position. Oligopolies exist in various industries and across all countries. Certain oligopoly markets exhibit high levels of competition, but others don't seem to have as much. The oligopolistic market structure builds on the following assumptions. One, that all firms maximize profits. Second, oligopolies can set prices. Third, there are barriers to entry and exit in the market. And fourth, products may be homogeneous or differentiated. And fifth, that there are only a few firms that dominate the market. Regretfully, the precise definition of a few enterprises is unclear. Typically, 3 to 5 dominant enterprises in a market make up an oligopoly. Now let's examine the game console market as an illustration of an oligopoly. The three major players in this market are Microsoft, Sony and Nintendo. As a result, they all have a substantial degree of market power. The fourth type of market is monopoly. When a single business controls the whole market, it creates a monopoly. Customers are at a loss for options, which gives the corporation the greatest market power in this situation. For this reason, monopolies often reduce output to boost prices and profit margins. The following assumptions are made when we talk about monopolies. The first one is the monopolist maximizes profit. Second, it can set the prices. Third, there are high barriers to entry and exit. And fourth, that there is only one firm that dominates the entire market. Society typically views monopolies negatively due to their tendency to result in poorer production and higher prices compared to competitive marketplaces. As a result, the government frequently regulates them. An example of a real-life monopoly could be the Indian Railways. They are the sole players in the rail industry. Now let's talk about the laws in action that are governing these markets. The first one is the Companies Act of 2013. The following goals guided the enactment of this legislation: to provide a comprehensive framework for regulating companies in India. Second, to make it easier for Indian companies to start and operate their businesses. Third, to promote corporate governance in India. And fourth, to improve economic development in the country by promoting entrepreneurship. The Companies Act 2013 is an Indian law that governs company governance. The Indian government passed the Companies Act 2013 on April 1, 2013 and it became operative on April 1, 2014, providing Indian businesses with a robust and efficient regulatory framework. The second regulation or the act is the Competition Act of 2002, which is recently amended and it has become the Competition Amendment Act of 2023. Since its passage in 2002, the Competition Act has undergone revisions to reflect various technological developments in the sector and to promote and sustain greater competition between market players. The Monopolies and Restrictive Trade Practices Act of 1969, which is also known as the MRTP Act, established India's own form of competition law 40 years ago. The MRTP Act established a regulatory framework in the country that prohibited monopolistic and restrictive trade practices and prevented the concentration of economic power in a small number of hands, which would be detrimental to the public interest. It was based on the ideas of a command and controlled economy. Following economic liberalization in the year 1991, it became imperative to establish a framework for competition laws that was both consistent with international standards and more aware of the country's economic realities. In order to control corporate operations in India and stop acts that have a noticeable negative impact on competition, the Indian Parliament passed the Competition Act in the year 2002. The Competition Act concentrates on three main categories of conduct, that is, combinations, which talks about mergers, acquisitions and amalgamations. Second is misuse of a dominant position or abuse of dominance, and anti-competitive agreements. On May 20th, 2009, the Competition Act went into effect after the Indian government published notice of its provisions pertaining to abuse of dominant positions and anti-competitive agreements. The Competition Amendment Act of 2007 later made revisions to the Competition Act. After 3 more years, the Competition Act's merger control provisions took effect in the month of June 2011. The Competition Commission of India, that is famously known as CCI, founded in accordance with the Competition Act, is solely responsible for enforcing and overseeing the Competition Act. The addition to the chairperson, the Indian government will appoint a minimum of 2 and a maximum of 6 members to the CCI. The CCI can start an investigation into an anti-competitive agreement or abuse of dominant position on its own, based on facts or information it already has, after getting information or after getting a request from the government or a legal authority. Abuses of dominant positions and anti-competitive agreements can be reported by anyone, including associations of consumers. The CCI can initiate an inquiry into mergers and acquisitions either independently or in response to a notification from the merging entities. The CCI has considerable authority to investigate claims of anti-competitive behavior through its investigating division. The Office of the Director General, or the DG, this power includes the capacity to summon someone and require their presence, question them while they are under oath, accept evidence in form of an affidavit, and take other actions. If the CCI determines a prima facie case, it will direct the DG to investigate the subject and report the findings. The DG also has the power to carry out dawn raids in order to further its inquiry. In a number of instances involving allegations of abuse of dominance, the DG has made use of this power. After providing the relevant parties with an opportunity to present their case, the CCI may adopt the recommendations outlined in the DG's report and issue any necessary orders such as cease and desist order and penalties. Under the Competition Act, certain CCI orders may be appealed to the Competition Appellate Tribunal, which was recently merged with the NCLAT, that is National Company Law Appellate Tribunal. The Supreme Court of India may hear a further appeal from the NCLAT's ruling. The next law that we are going to discuss is the Securities and Exchange Board of India Act. The Securities and Exchange Board of India, that is SEBI, is the regulatory body responsible for overseeing the functioning of the Indian securities market. It was established in 1988 as a non-statutory organization, and it was given statutory authority by the SEBI Act of 1992. The regulation of the security businesses in India is contingent upon the presence of SEBI. Its main objectives are to ensure honest and transparent dealings with securities and to protect the interests of investors. In the securities market, under SEBI's jurisdiction are stockbrokers, merchant bankers, and other intermediaries. It also ensures listed businesses adhere to the guidelines and standards it has set forth. The task of supervising the functioning of the Indian securities market falls to SEBI. It monitors the activities of various market participants to ensure that they adhere to the guidelines and standards it has set forth. SEBI also conducts inspections and investigations to ensure that there have been no wrongdoings or violations of regulations. By means of its expansion and advocacy, SEBI plays a role in advancing the securities industry. The introduction of new products and instruments, the encouragement of foreign investment, and the advancement of investor education and awareness are only a few of the measures that have contributed to the development of the Indian securities market. Furthermore, SEBI has upgraded the infrastructure and technologies used in the security market. One of SEBI's primary duties is to safeguard the interests of the investors. It does this by ensuring that publicly traded corporations provide investors with accurate and timely information by putting an end to insider trading and fraudulent activities, and by enforcing the law against those who violate it. Additionally, SEBI educates investors about the advantages and risks of investing in securities and provides them with a grievance redressal channel. SEBI plays a major role in the growth and promotion of the Indian securities industry. To increase market liquidity, it has put in place a variety of policies such as allowing algorithmic trading, allowing the introduction of new products like equity derivatives, and allowing short selling. Additionally, SEBI has relaxed certain regulations in an attempt to encourage the listing of startups and small and medium-sized enterprises. These steps have made the market more sophisticated and enticing to investors. SEBI regulations mandate that companies provide investors with timely and accurate information. Listed corporations must follow the conditions of the listing agreement and disclosure responsibilities, which include providing the stock exchange and investors with access to critical information such as financial statements and board meeting minutes. This rule ensures that investors may be knowledgeable judgment and encourages transparency in the securities industry. The next law which governs the market is the Consumer Protection Act 2019. The process of defending consumers against deceptive business tactics is known as consumer protection. It describes the measures implemented to safeguard customers against deceitful and deceptive business activities by producers, distributors, merchants, and additional service providers. Furthermore, clients are provided with the means to initiate legal action in event of rights infringement. The Consumer Protection Act of 2019 governs the administration of consumer rights protection in India. The Consumer Protection Act replaced the Consumer Protection Act of 1986. Many of the provisions of the modified act tackle the challenges posed by modern tech-dependent consumers. The act also includes several provisions aimed at defending the rights of consumers. The Indian legislature created the Consumer Protection Act 2019 to handle issues related to violation of consumer rights, deceptive advertisements, unfair business practices, and other circumstances that damage consumers' rights. Technology improvements have led to a considerable increase in the number of people buying and selling products and services online. Therefore, the Parliament intended to act to include protections for e-consumers as well. Now, consumer protection councils are created by the Act to settle disputes as they arise and offer fair compensation to consumers whose rights have been violated, thereby better safeguarding consumers' rights and interests. Additionally, it provides fast and effective alternative dispute resolution for client complaints. The Act also promotes consumer education to let people know about their rights, responsibilities, and complaint resolution procedures. The next law that we will be discussing today is the intellectual property rights. Now, the protection of intellectual property is essential to a country's progress. Each nation has its own unique set of intellectual property laws. In many industrialized nations, the strict application of the IPR function contributes significantly to economic progress. IPR stimulates innovation, benefiting the economy. Nowadays, innovation forms the cornerstone of any firm on the planet. In the present period, the importance of IPR laws is widely acknowledged. In the modern world, reputation is just as significant as creativity. The name carries a significant amount of affection. Some companies merely take huge payment amounts in return of selling their brand. Intellectual property rights have a major role in a nation's capacity for financial prosperity. The IPR has been linked to both positive as well as negative growth in economic development. Since invention and creation are directly tied to the advancement and growth of the country, it is imperative that people's rights and interests in their endeavors be protected. The role of intellectual property in the economy is, number one, to provide exclusive rights to the creator, to protect the interests of the creator, and to encourage investment in research and information creation. Second, to forbid the competitors or anybody else from exploiting or misusing the property without the permission of the creator. And third, to create a market for that invention so that it could be put to good use and will motivate others to innovation and creation. So these are certain laws in action in the markets in India. I hope you learned something today. Thank you very much.